And see what's happened to it.
Good afternoon. Holy cow, it's April. Welcome to the Senate Committee on Government Operations. No fooling today.
Good option.
Up first is H10, which is an act relating to approval of amendments to the charter of the city of Barry. Each of you on your desk should have a copy of H10
We do.
as passed by the House. And we're happy to have Michael, is it Booten?
Booting, yep.
There you go. He is the sponsor of the bill. And also joining us is Tucker Anderson, who drafted the bill. And then we'll hear from Carol Dawes, who is the TIP administrator. I thought she was city clerk.
She was.
She retired.
Yep.
Ah, okay. So, Michael, do you know all of us? We can quickly introduce ourselves.
So I know most of you.
Okay.
And I put your name on cards, but I can't remember your.
Okay.
Go ahead, Larry.
Harlan.
Larry Harrison County.
Allison Clarkson, Windsor District.
Brian Collmore representing the Rutland District.
Jillian, Committee Assistant. Tanya Bahovsky, Chipman Central District. And I'm Becca White, and I'm from the Windsor County District.
So welcome, Michael, and let us know if you would how this came about. I assume it all happened on town meeting day.
It sure did. So, we'll start with the school charter changes, back before Act 46, I think it was. We actually had our own school district. It was in our charter. It was in there. And when they went to their own district, the charter language did not change. The legislature did not clean up charters, which had school district language in there. So it's a vestigial piece of the charter that needs to be removed.
Okay.
So for cleanup.
It is. It's just cleanup. We had to get it approved, and it was approved. Then the next one is moving the town meeting day to May. Barry Town does have their meeting day in May. So it's not like it would be completely outside of the realm of normal. We have had our meeting day in May before. We moved it back in 2005, and then it was moved back in 2007. But then, and it didn't really see just how beneficial it was until the last 2 years when we've had it in May. It allows the manager to have the opportunity to have way more information available to them or to him currently.
Nicholas.
Yeah, Nicholas. In order for him to draft the budget. It's extremely beneficial in that situation. And then, of course, the separating of the clerk and the treasurer position.
Yeah.
We did have it as one position. However, we have decided that we wanted to put that treasurer piece into more of a professional, because it's dealing with funds. But we want to currently keep the clerk as an elected position. I will say that the charter changes passed overwhelmingly, specifically the separation of the clerk and treasurer. It was 1,057 to 424. And then the charter changes to remove the school language, also 1,061 to 389. It was a little bit closer with the charter change for the dates, only because there was some political stuff where it just became an issue.
What was that vote?
That vote was 899 to 618. So it was resounding. And I will say that when we moved it to May, we had a huge turnout. In fact, the turnout that we had in May was far higher than it's ever in March.
So is it on a Saturday?
No, it's on a Tuesday, second Tuesday of May. Sorry, second Tuesday of May. If we change.
Yeah, we'll have Tucker walk us through them.
Yeah.
Do you have questions for Michael?
I do have a couple of
Yeah.
questions. My first question is, thanks for bringing, this is actually a comment, not a question, is thanks for bringing the numbers, but how many registered voters are there in Barry?
So the registered voters in Barry is around 6,500. The highest for voting is somewhere around 3 to 4, and that's during presidential.
Mhm. Yeah, I'm just always curious to know what percentage of folks are.
Yeah.
And then is there any concern around the change from March to May that charter changes would be held up in this building? So they wouldn't get to us until late May. They wouldn't have to wait a whole year till we're back to pass.
No,
Good
and
point.
and it is a good point, except for what we have noticed, and I was a city councilor for 14 years, is that even if we pass the charter changes in March, they don't usually get approved until the following year.
When was this charter change that we're looking at passed? Was that passed this March?
It was passed in May of last year.
Okay,
Oh,
Well, if you've been doing it in May, that's why.
yeah.
No, last year was, it might have been the first or second year that we did that. But in previous years, we have noticed that they do get, usually our charter changes get done like the following year. At least that's what I remember.
I don't.
But it gets to both of the other senators' points. That's because you chose to wait until May.
No, when we had it in March.
Oh,
Yeah.
that's,
That's,
I find that
I'd
hard
love
to
to look
believe.
at that, because we usually pass pretty much every
Yeah.
charter
It's
change.
possible, and the one that I'm thinking about definitely was a year.
Okay,
Wow.
all right.
Wait, if you get that to us, I'd love to see that, because very unusual.
And how did you switch it to May? Did you do that through a charter change?
So I believe, I'm not sure what I believe that there is some sort of language that's pandemic related, but I might be wrong.
Yes,
Oh,
it was pandemic related. We allowed towns, to set
Oh.
times,
Yeah,
their own times, and you guys chose May. So that was, and Carol can update us on this,
Yeah.
because I know Carol knows.
Yeah.
But that was, we enabled that in 2021. Because we already passed town meeting by the time 2020 hit.
Right.
But we had allowed those changes for 21 and 22, I think.
yeah.
Carol
And
will know, but
and it might be flood related that allowed us to, I'm not sure, Carol. I'll defer to you for how we were
Well,
able to
again,
do it.
just procedural, I'd like to get Tucker to walk us through the bill
Yeah,
before we hear from Carol. Is there anything else you wanted to let us know?
I don't think so.
Yeah,
I
certainly.
can give you the numbers for voter turnout for the last 15 years if you want, but
If you could email it to.
That would be great after you would email
it's on
it.
the website, but I can definitely email it.
Okay,
I'll email it to you. Right.
everybody, okay? Okay, thanks, Michael, for coming in. We appreciate your time.
thank you, Michael.
Thanks for
You're
your
welcome.
card.
Hey, you're welcome.
Tucker, if you'd like to join us and walk us through the bill, the charter.
Sure.
Good luck in commerce. Watch out for that wild man
Oh,
Marcotte.
God.
Hi,
Afternoon.
how are you?
Oh, Tucker, there's
Great
Kate
tie.
in the sergeant at arms office.
Now I'm ready for Kate.
I know you are. You're ready for me too. Look, I got some.
Tucker Anderson, Legislative Counsel, for the record, you have in front of you H10, as passed by the House. How wonderful. Which contains amendments to the charter of the city of Barry. And I'll start by just confirming the committee's suspicions and discussion about how the city got to a May annual meeting date prior to these charter amendments. And the answer to that is yes, the temporary authority that was extended to all municipalities in response to the COVID-19 pandemic. Initially, that authority was tied to the state of emergency, but then for 2, maybe 3 consecutive sessions after that, Act 1 in the biennium extended that authority for
Right.
essentially
Okay.
2 years the first time, and then 1 year the second time it came through, which got the city into 2024, and now you have this bill in front of you.
To your knowledge, were there any other municipalities that took advantage of that flexibility?
So there were quite a few, and one of the concerns that came up at the time was really around the timing of municipal and school district budgets lining up with the fiscal year and in particular with the reporting of those school district budgets. So there was at one point a chart that we were keeping to see when the annual meetings for both municipalities and school districts were being shifted to kind of track where some of those, decisions, when those decisions were being made that could have an impact on the state finances.
Okay.
But yes, there were quite a few municipalities that either to accommodate shifts in voting practices at the municipal level for purposes of the COVID response. So that it could be, for example, shifting to Australian ballot, or just to buy time to shift out into the spring when they could, for example, hold annual meetings outdoors, for purposes of maintaining the tradition of floor meetings. There were quite a few municipalities that moved their annual meeting date.
I didn't officially welcome Senator Jehovsky back.
It's good to have you
Thank
back,
you.
Tom, and
People have a-
wonderful adventure.
Tucker
And
Anderson
if we could
question.
talk about it.
No, I actually have the previous witness question, but
Oh,
Tucker might be.
I'm sorry.
No, it's okay. It just popped in my head.
Oh.
But Tucker tends to know many things. So I'm gonna
does.
ask him, and if he doesn't know, it's gonna be okay. It's not a legal question, and that, well, it kind of is. And that is, the city of Barry held their town meeting in March 2025, or did they hold it in May again? And if they held it in May, how did they do that? Given that the extension for that isn't in place.
I did not keep track of when the city was holding their annual meeting, but
Okay.
This says May 14th, 2024.
Yeah, but that was 24. I'm wondering when they held it for 2025.
Oh.
We passed town meeting 2025, so this wouldn't apply retroactively to allow them to not hold it in March
Yeah.
of this year.
But I bet Carol has the answer.
Okay. Like I said, I wanted for,
Okay.
Carol's smiling, so she has the answer.
Can we ask her?
Sure. Carol, welcome in. I'm sure Tucker won't mind the brief interruption.
Oh, sorry.
Thank you. For the record, Carol Dawes. I'm the former Barry City Clerk and Treasurer, and I shepherded these charter changes through last year's town meeting election in May when they were approved. The reason both last year and this year why Barry City has been able to schedule its annual meetings for May, in addition to the language that was allowed because of the pandemic, is because the way our language currently is set. It says the first Tuesday in March, or as at a date set by the city council. So there is actually authority in there now for the council to select a different date. And so last year they pushed it to May because we were still dealing with the budget impacts of the flooding from July of 23. And it turned out that it worked so well as far as being able to have clearer numbers for developing the budget, that they put the charter change in front of the voters, which the voters approved, and the council again set the town meeting vote for the second Tuesday in May this year. So Barry City voters will go to the polls on May 13th, 2025.
Okay. So the vote totals that Michael gave us were from 24.
Correct.
All right. Thank you, Carol.
Yep.
Tucker, please go on.
excellent.
Can we just go back to May for a second? Because
Sure.
Carol, why May? I mean, I know what he said, Nicholas feels that that you have a notion of where the state's landed and a lot of other budgetary things, but holding out your budget vote on, and I know this separates the school piece out.
Yeah, the city.
I mean, so when is the school vote now? Is the school vote still in March?
Yes, the school vote is still
Oh.
articles of agreement. The school vote is held on the first Tuesday in March. The reason for May is so that we are, and actually Representative Booton mentioned this in
Yeah.
it sets us up on the same schedule as Barry Town. And so since so many people think of Barry as one community, it made sense for us to mirror their schedule. So both communities do school voting on town meeting day and do municipal voting on the second Tuesday in May.
Thank you.
And sorry, just one last question.
Sure.
Is your year end May 31st or is your, I mean, what's
What-
your year? Yes. May
June
30.
30.
June.
Yeah.
Okay. Okay, great.
Okay,
Thanks.
sir.
Onward. We'll start with section 1 and just note that that contains the General Assembly's approval of the charter amendments.
Mhm.
Section 2 contains the substantive amendments to the city's charter. First, in section 110, the technical cleanup that Representative Booton referred to, removing references to the city school district.
Yeah.
In section 111, some more technical cleanup. In section 202, the first substantive piece that you're seeing here in subsection A of section 202, the city's annual meeting date shifted from the first Tuesday in March to the second Tuesday in May.
Now,
Senator White.
why the second Tuesday versus the first Tuesday?
These are policy
Their choice.
considerations made by the city and
Okay, it wasn't because there's some weird thing that we have statutorily.
the weird thing statutorily would likely be the town of Barry's charter in Title 24 appendix, which names the same date.
Okay.
Makes sense.
Section 203, more technical cleanup, eliminating reference to the city school district. In section 205, if you are with me.
Yep.
As passed by the House version. This amends the list of elected officers to separate the office of city clerk and city treasurer. And in some of the repealed subdivisions, you're seeing eliminating references to the city school district and school district board. Section 206 is amended to eliminate a reference to school commissioner. Section 207, interestingly, this was not in the charter amendments approved by the voters, but is here to be consistent with the other decisions that were made in moving the annual meeting date and was initially flagged, of course, by the excellent Carol Dawes, who reached out to say that this was missed prior to holding the vote to amend the charter.
So this.
Yep.
So this doesn't have a substantive change to the policy, but rather just correction of the dates within it.
Correct.
Okay, so that you wouldn't, yes, we should do that if there are any instances.
And
That would be really annoying.
here, this had specific call outs to the annual meeting in March for purposes of this section for approving the budget request of the city manager.
Okay.
So to be consistent in making sure that the annual meeting day referenced throughout the charter is the second Tuesday in May, these changes are made here.
Okay.
In section 301, if you shift on to page 5, the city council is granted the authority to appoint and remove a treasurer and assistant treasurers who will be responsible for the duties of treasurers under general law.
Senator White.
Can you tell me a little bit more about what the treasurer does under state law? Because we have a fantastic treasurer in Hartford. It's this guy named Joe Major. And we also have an assistant treasurer who's more of a professional. Well, okay, I'm trying to think of a way to put this. They're like a staff member versus Joe is an elected person. He's a little bit more of a, he kind of keeps track of things, signs documents, looks over the budget generally, but is not crafting the budget or working in the fiscal department. It's not a staff role. Is this person now you have the clerk, you have your treasurer, and you have an assistant treasurer, or did they currently have a clerk? Just explain this whole thing to me because I'm not.
For purposes of the city, they currently have a clerk and treasurer, one position. This charter amendment will separate those two positions out and allow a treasurer to be appointed by the city council. And They may also appoint assistant treasurers who would serve under the treasurer. To your question about what treasurers do under state law, can generally describe their duties in Title 24 specifically as moving money into and out of the accounts of the city. So they approve the issuance of money. I believe they call it drawing money from the accounts of the municipality, and in general manage the various accounts that a municipality has.
And is assistant treasurer spelled out in state statute? Like what's the way in this? Yeah. Can that be a staff person? Or do they have to be?
I have to say this all the time, and I'll say it again here. I wish that my encyclopedic knowledge of my subject areas was so deep and detailed that I could tell you whether or not the duties of assistant treasurers are specifically called out in state statute. But I can't recall, so I will
Can
look
I-
it up and
Okay, I'll just explain why I'm asking is we had a long discussion in Hartford about an appointed versus an elected treasurer. And if you want that to be one way or the other, can be dependent on the size of your community. Like we basically needed a person full-time.
Yeah.
And that's why we went to appointment for our town clerk, for example, versus election. So I just want to understand, is this policy-wise also addressing a shift within the government structure to have a professionalized appointed person, or is this just making a change? So I just want to understand a little bit more. And it doesn't determine how I feel about it. It's just I'm trying to.
But that's also an assumption, because there are many electeds who are full-time professionals.
Sure,
I mean, so there's no assumption that just because you're appointed, you're a professional as opposed to those who are elected.
and this is the heart of the debate.
Yeah, and I think that,
I just want to understand what the discussion was and if this is making a substantive change or if this is just helping out the clerk not have to sign all the checks that she has to sign.
I don't know the answer to that. It would appear that they haven't had an assistant treasurer before.
Yeah.
So this creates that position, which can be appointed and removed by the city council.
Yeah.
General law, just to point this out, does allow for any municipality that the town or city treasurer may appoint an assistant town or city treasurer. So this ability already would have been available to the city treasurer. I guess
So
perhaps
just separating it, the town clerk treasurer could have done that. Now they could have had an assistant treasurer, could have had an assistant clerk.
Except the important distinction here is that the way that the city is amending their charter here in subdivision 2B, assistant treasurers would be appointed by the city council, not by the treasurer themselves.
interesting.
See, that's, yeah, okay, interesting, okay. It doesn't persuade me one way or the other to be supporter, but it's just.
For our edification, cooperatively, 24 VSA section 1573 is the statute that is specific to the assistant treasurer, and details appointment authority for assistant treasurers, but does not contain any specific separate duties from the office of the treasurer. So it would be a more detailed legal analysis than I have capacity to do on the spot for you, but that would mean that elsewhere in Title 24, wherever a duty is specifically called out for the treasurer, it would be to the exclusion of the assistant treasurer, actually. But I would have to look up if any of those instances exist.
Senator Bielski.
Are there other places, and again, you may not know offhand, but I'm wondering if there's other spaces or towns or places within state law where we have an appointing authority that is appointing someone who is going to work underneath someone else who is not in control of their appointment or job. Do you know what I'm, because it's interesting to me because presumably the assistant treasurer would be working for the treasurer, yet the treasurer is not appointing them or having any supervised. Do you see the disconnect I have here?
It's not their boss.
Right, and so I'm wondering if there's other
That's the
examples in
council.
other charters or other places in state law where we do this.
I can look some of it.
Thank you.
I miss having you here.
And is the same thing true for assistant clerks? Because
Well, so the place that I sort of most think about it is, the city council in many towns appoints a police chief, but they don't appoint all the officers and all of the people that work for the police chief.
gets to hire
So
that.
Harrison.
Exactly.
Yeah.
Which is why this seems strange to me.
Okay.
Although I, for other reasons, was just looking at 24 VSA, chapter 55 this morning, and the language around the creation of a police force at the municipal level does say that the legislative body has the authority to appoint individual officers to the police force.
But they don't.
So
It's
we can't.
interesting.
I don't know.
That's interesting information for me to have.
Judiciary.
The committee's ready.
Yeah.
Moving into section 3, there are a series of repeals. So sections 413, 516, and 517 are repealed from the city charter, and all of those sections relate to the city school district and officers of the city school district. Section 4, this act shall take effect on passage.
Okay. Any questions for Tucker? Other questions for Tucker? Okay. You are dismissed if you so choose, or you can certainly
Wait,
take a
we
seat.
don't have another.
Carol, how are you? And welcome in. I assume you heard our introduction, so
I didn't.
on the table again, but great to see you. I remember your testimony many times in this committee
Bye, Tucker.
in years past.
Yes, much time spent both in person and virtually with all of you, and so it's a pleasure to be back. So again, for the record, Carol Dawes, I'm the former Barre City Clerk and Treasurer. I served in that capacity for 16 years, retiring just not quite a year ago. But I have continued to be involved, particularly shepherding this particular charter change through. I do want to provide a little more information with regards to the proposed separation of the clerk and treasurer. As I said, I was both for 16 years, but there have been a number of changes that have happened in the city of Barre over that time, most notably the growth of our finance department. We now have an extremely robust finance department, and our assistant city manager is also our finance director. She is a professional. She leads a professional staff. At the same time, the amount of clerk work has increased. And so attempting to do both, we realized was difficult. And so it made sense to allow the clerk to focus on the clerk work and to shift to what will ultimately be a part-time treasurer serving in that capacity to do the work that is statutorily required of treasurers, which is primarily oversight, banking, investment, those things, and obviously working closely with the finance department. We do have an assistant treasurer who does the day-to-day money work in the clerk's office, processes, payments for taxes and dog licenses and marriage licenses, and makes bank deposits and those kinds of things. So that's what the assistant treasurer does and will continue to do under this model for the city of Barre.
Did I wait?
Thank you, Mr. Chair. Carol, you answered all of my questions about the reason why, because I was trying to understand if it was just not even a policy decision, but just more of like a logistics change. And if I understand you correctly, the assistant treasurer position, is that a hired position for you?
Yes, it is. And in the city of Barre, all white collar workers are hired and are members of the Steelworkers Union. So it's all union positions in City Hall.
Okay, thank you for that update because I think that helps answers a little bit of your questions that are around. So did the assistant treasurer, there's no change to that role kind of within the charter other than now you have a different person who takes on the treasurer role. And the way I think we were wondering about to your question was, is the assistant treasurer now being hired by the city council with this change? Or are they remaining as a staff position? And that might be a Tucker question,
Mhm.
but I think that was kind of what I was trying to bumble my way through earlier was, is this a change to that position structure in any way?
It isn't really a change. Up to this point in time, during my tenure, while I appointed the person, they were a Berry City staff member and a member of the union. So they reported to me. We're waiting for the charter change to finalize before we work out the details going forward, but in all likelihood, the assistant treasurer will report to the finance director going forward because the treasurer will be a part-time position. But there should be no change in the functions that are performed by the assistant treasurer.
Senator Clarkson.
So just to follow up on Becca and Tanya's points, Carol, did you hire the assistant treasurer? You hired them, right?
I was involved in the interviews and certainly had a say in the person that was chosen, but they were hired as employee of the city by the city manager.
That feels, I appreciate that. And, you know, we don't want to micromanage, but I do think that makes a lot of sense as an organization to have. If you've got a professional person, professional is not the right word,
Yeah.
like staff person,
I
like
think on staff.
on staff person reporting to another on staff person is a good setup. So it sounds like that's being maintained rather than having some kind of random,
Right.
in some regards, elected person at the whims of voters being your boss when you're a staff person. I think that can pose some challenges, and it sounds like that's not what you're doing. So I appreciate that. Thank you.
But, and the one position that's gonna still be an elected but a staff person is clerk. I mean, the town clerk
Correct.
is the staff
And the
person, but
mayor.
they are elected.
Well, it's funny that you say that. They actually are in the middle of discussions right now about whether they want to put a charter change forward that would make clerks appointed. I'm vehemently opposed to that. So if it goes forward,
We
you'll
remember
see me here on the other side next year.
No, we've already heard,
It's so-
we've already
it's so
heard from you
funny.
about this.
There's
before.
There's pros and cons.
Right.
The main reason I'm against it is that I think that it is really important to have an independent person in charge of elections in a community. I think it's difficult to have somebody supervised by the council who are elected, the members who are elected. And I think that creates some potential conflicts. The other thing is that I really see a clerk as a liaison between the voters and the administration of a municipality. It's the clerk that actually works with the administration and creates that bridge. And I think that it's important to keep that as an independent elected office.
I don't disagree.
Is there anything else that you wanted to?
No.
No?
I will be so happy when we get the school language out of the charter. It's been driving me nuts since 2019 that the charter completely contradicts the articles of agreement for the school district, and yet this seemed to be the only way we were able to do it. So that will make me very happy.
Okay.
A good catch on the additional
Yeah,
section.
yeah.
I know Tucker referred to me as excellent, but I'm only semi-excellent because if I'd been excellent, I would have caught it.
You're the first.
I was gonna say you're caught it before we went to vote.
So in the city of Berry, the mayor, the city council, the town manager, and the clerk are all elected. And the,
Not
Am
the
I-
city manager.
oh, I thought I read that.
Elected.
No.
They
We
hire.
have a mayor, we have a mayor, though.
Okay,
It's the mayor who's elected, but the city manager is appointed
Correct.
okay. Yeah,
and he runs the show.
okay, well, we'll try to expedite this for you. We won't wait till a year from May. We'll get it done this year and go forward.
I appreciate it. Please feel free to reach out if there are any lingering questions. I'm happy to be back.
Well, we have one that's not lingering because it's going to be asked right now. So
Yeah.
you don't speak.
It just popped up, the conversation around the change in date from, March to May was sort of pointed out that there, that was closer, there was some dissension. What was that about? Why were there so many more people that disagreed with that change? Do you have a sense of the sort of the community discussion around that?
I'm not sure that I have any real solid evidence. If I had to, a conjecture would tell me that some of it is tradition,
Mhm.
tradition, and that certainly played some part in it. And the other thing is that even though it makes sense for Berry City and Berry Town, since we're one community, to be doing things on the same time frame, there is not animosity, but there is some kind of like sibling rivalry between our communities, and there may have been some of that I don't want to do it like them kind of routine. So, but we're going to grow out of that phase eventually.
I hope so. As a resident of Essex Town who grew up in Essex Junction, I am somewhat familiar with some of where this can go if you don't grow out of it. So I hope that you do and appreciate that insight.
Well, and this is a step towards it, right?
Aligning, yeah, well, so Essex Town and Essex Junction
Oh.
have different dates.
Yeah.
But yes, so as someone who shares a city-town relationship challenges, I appreciate that, and thank you.
Thanks, Carol. Always good to see you.
You too. Thank you.
Take care. Okay, committee, we'll move now to H1. Again, this is,
Something for Terry.
yes.
Oh,
Tupperware.
We
she
have.
never wants the Tupperware back, but if you're
Oh,
taking
okay.
it.
You are?
want me to switch you? Do you know? Yeah.
I don't believe it. Okay.
How do you know there were cookies in there?
So my dear, trifle this morning for the pages?
Well, I inherited
I'm gonna
Senator
remove it.
Kitchell's tradition apparently, because she's
So
been,
how did you inherit that?
well, Agatha mentioned that it was a tradition and that it was a shame for the tradition to have ended. So I said, well, I'm happy to if you would like.
Oh
So
my God,
that's how I
Terry, you're
kind
so
of.
good.
And then,
That, but they loved it.
Oh, I'm
And that is
glad.
clean for you because you bring us far too many of these.
well,
Thank you.
my pleasure. I walked by and it was empty, which I was so surprised because I wasn't sure how many pages there were. So I made like a extra large size.
Those kids.
There are only seven, there are only seven of
Empty.
them, so you can imagine many other people took advantage.
They're zooming around here, doing chocolate.
So again, just for the edification of all concerned, we're going to take testimony from Terry Corsones, Merrill Bent, and Carolyn Anderson today on H1. Over the weekend, all the committee members, and I'm sure Jillian did forward it, should have sent additional testimony from Professor Teachout, specifically regarding the judicial branch and how H1 might impact that. And I think for Terry's benefit, because I don't know that you know, tomorrow, John Bloomer and Betsy Ann Rask will be here to testify as well on H1. I think we're probably going to have a full 45 minutes or maybe an hour hearing from those two folks. So
Terry, did you have a chance to see Peter's testimony?
I did. Senator Collins kindly sent it
Oh,
last
great.
evening, so I did see it.
So with that as a preface, welcome in. It's great to see you as always, and you'll know the committee members. So let's get to work on H1.
Right.
These are no fools. Those are real.
Well, thank you, Mr. Chair. Terry Corson, State Court Administrator, and I'm joined by Merrill Bent, who is the Chair of the Judicial Conduct Board, and
Oh.
Carolyn Anderson, who is chair of the Professional Responsibility Board. So we'll see if
And
Carolyn.
Meryl is mine.
Mike Kennedy is bar counsel.
Oh, Barton.
Yes, Marilyn, I think Bonnie Badwick might have been your predecessor as chair of, or, no, that's Professional Responsibility Board.
My predecessor was Barb Blackman.
Barbara Blackman was the chair of the Judicial
Okay.
Comment Board before Meryl.
Do you have a particular order that you want to follow or?
Well, I'll be just doing a brief introduction.
Sure.
And then I think Meryl was going to speak in her capacity of chair of the Judicial Comment Board. And
Okay.
Carolyn, I guess just to make sure Carolyn is connected.
I am here
Oh,
and my
okay.
camera says that it's on, but I don't see you. Or you don't see me, it doesn't look like.
No, we don't see you,
Uh,
but we can hear you.
I think you're gonna see me in a second, maybe? Huh, hang on one second, I'm sorry.
Oh,
There you
go.
now we see you.
Now
Sorry
you're.
about that.
Yeah.
All of a sudden I got a little pop-up that said the host has asked you to start your video, so that's what I did.
Okay, great. Thank you,
Very well,
Carolyn.
host.
Thank you.
Okay, so welcome in, all three of you.
Well, thank you. And we were scheduled last week, and
Yes.
in conjunction with that testimony, we had provided a memorandum, which I don't know if you all, I have an extra
Oh,
copy.
okay.
if
I
you'd
love
like
it.
it. Okay. So I'll help that out. It's something that was on your page that day, and it was, I forget, I think maybe the floor went long, and that's why
You did.
They went super long.
they were rescheduled. And I do also have a copy of Professor Teachout's memo if.
Yeah, we have.
Is that?
Yeah, he didn't give us a copy. I don't know if it was put on the website.
He did, we got a printed out copy.
I
did.
didn't take a printed copy.
Well, there, but Jillian, David, I have it here.
Well, and actually what we're doing is modifying our testimony quite a bit in light of Professor Teachout's memorandum,
Okay.
which I personally am very grateful to Professor Teachout, because in the course of his looking at the issue of how separation of powers argument affects the judicial branch, in particular the Judicial Conduct Board and the Professional Responsibility Board, he basically acknowledges and accepts and puts forth the same arguments that we had put forth in our memo last week. And so with that, he acknowledges and specifically cites in his memo the very same points that we were making. In particular, special ethics standards apply to lawyers and judges. And I'm reading from his memo.
Yeah.
Because of the unique roles they play in our system. Standards that do not have general application to other government officials and employees, which was the point that we were trying to make. Ethics is at the heart of the legal profession. We're required to have strict ethical standards. And for example, it's part of law school training. When you take the bar exam, there's a whole separate section for ethics. We have mandatory continuing legal education requirements of 24 hours every 2 years, 2 hours of which are required to be ethics. It's something at the core of licensure requirements. And that is not the case for, as he pointed out, other governmental officials and employees. So there is that distinction.
Where are you in Peter's?
She's on hers.
You're on page 3.
Second paragraph. Second, he noted that both the Professional Responsibility Board and the Judicial Conduct Board already have well-established procedures for conducting investigations of ethics complaints and making disciplinary decisions, and have had a long history of implementing those procedures. And I just showed you by way of illustration. These are the Vermont Rules of Professional Conduct. These are this is the Vermont Code of Judicial Conduct. This is Administrative Order 9, which oversees the Professional Responsibility Program. Very robust, very detailed, very established methods for conducting the kind of disciplinary procedures and systems, which is quite different from, I'm going to suggest as a member of my Midland Planning Commission, municipal bodies. We, for the first time, have a municipal code of ethics. And that's where I feel the State Ethics Commission is playing an invaluable role it's fantastic and that's what's needed. But to me, it's very different and distinct from the same requirements applying to the Judicial Conduct Board and the Professional Responsibility Board. He also points out there are special confidentiality requirements that must be observed in professional and judicial conduct board ethics violation investigations that could potentially be compromised if the respective boards were required to consult with the Ethics Commission, which is what H1 is designed to point out that we're suggesting and arguing that we should be exempt from that because we're not even allowed to have the consultation requirement because of our confidentiality claims. He acknowledges that and he accepts that. And with that, he said really the only way that you can have a consultation requirement, this is his expert opinion, so long as any required consultations are scheduled after the formal complaint has been filed, which is not the case with the present law. And H1 is designed to prevent that from going into effect September 1, and that's why we support it. And then he mentioned, even if we looked at that very small, much more limited window, for when he's even saying that it would possibly coincide with separation of powers issues, he said that, and again, I'm just reading from it, because we have these well-established procedures for dealing with ethics complaints and substantial experience in dealing with these complaints, unlike the context where the government body involved does not have established procedures and substantial experience, what we're saying is, in all honesty, every place else, nobody else has this kind of robust mechanism in place. Professor Teachout indicates the primary role played by the required consultation, if the existing law continues with this mandated consultation, would not be to provide an occasion for the Ethics Committee to provide guidance and advice. It wouldn't play that role. He said, if anything, it's likely that Ethics Commission itself would be the primary beneficiary. So if there was a consultation requirement, it would be to benefit the Ethics Commission, who could maybe then learn something about our process. But we're saying, is that a reason to require us to consult with them? We're suggesting not. And Marilyn Carolyn will speak with particularity about the Judicial Conduct Board and the Professional Responsibility Program Board, why we feel this consultation requirement just does not make sense. It's not appropriate under our rules that the Constitution gives the Supreme Court the exclusive authority to discipline lawyers and judges. They would not serve any practical purpose. So that's kind of our position. So again, we're very grateful to Professor Teachout for spelling out the same reasons why we have said, this to us, we're not trying to shirk anything ethics. We've got kind of this body of ethics. But to have a consultation requirement, we feel just did not make sense for those reasons. And Marilyn Carolyn can speak again to their boards with even more specific examples.
I don't know who wants to go first, but
I'm happy to.
okay, great. Thank you.
My name is Meryl Bent, and I am the chair of the Judicial Conduct Board. I've been on the board for several years, but I took the chair position at the beginning of this year. I want to start out by just fleshing out the Judicial Conduct Board's process a little bit for you, because I think it is an important backdrop to this discussion. My goodness. As Terry mentioned, the JCB's process for enforcement of the Code of Judicial Conduct is robust and comprehensive. And as explained in my memorandum to the committee, the code applies to judges all the time, not only when they are performing their judicial functions. The rules for disciplinary control of judges, which are promulgated by the Vermont Supreme Court, grant the Judicial Conduct Board broad jurisdiction over the conduct of Vermont's judicial officers. The Judicial Conduct Board also has continuing jurisdiction over former judges for conduct that occurred during their judicial service, as long as a complaint is made within 3 years. The JCB is comprised of 3 judges, 3 attorneys, and 3 laypersons who are neither judges nor attorneys. The JCB is empowered to receive information, investigate, dismiss unfounded complaints, enter into deferred discipline agreements, issue written warnings, conduct hearings, and adjudicate complaints of misconduct against judicial officers, and to impose sanctions for judicial misconduct and disability. The JCB has broad investigatory and subpoena powers in order to effectuate its authority. And when a formal complaint has been initiated, the matter becomes public and proceeds as a quasi-judicial administrative proceeding, which includes discovery and requires conformity with the rules of procedure and evidence that are applicable in civil actions. So in short, it is a very formal process, and it is a process in which the respondent judge is entitled to due process under the law. Sanctions that the JCB may impose include, but are not limited to, written warning, public reprimand, limitations or conditions on the performance of judicial duties, and suspension for all or a portion of the remainder of a judge's term in office. The Judicial Conduct Board's powers are always subordinate to the authority of the Vermont Supreme Court. And I agree with Terry that Professor Teachout's analysis has narrowed the issue considerably, but in my opinion, limiting the consultation requirement to the time frame after a complaint becomes public, as Professor Teachout suggests, still doesn't resolve the issues as they relate to the Judicial Conduct Board. This is because the consultation requirement would still directly conflict with the rules that have been promulgated by the Vermont Supreme Court for the disciplinary control of judges. And the disciplinary control of judges is exclusively in the Vermont Supreme Court's exclusively under the Vermont Supreme Court's authority. While Professor Teachout correctly states that after a complaint is filed formally, that complaint becomes public, the rules for the disciplinary control of judges still prohibit any member of that board from discussing their deliberations on matters before it with anyone outside of the board other than the board clerk and the board's legal counsel. That means that the board cannot discuss the application of its code, of the Code of Judicial Conduct, to a particular set of facts with anybody who's not described in that sentence, which is other members of the board clerk, and board legal counsel, because doing so would necessarily provide insight into the board's deliberations.
Meryl, can you pause for a second? Senator White had a question.
Thank you, Mr. Chair, and thank you as well. I just want to say this subject matter is extremely hard for me to understand and follow. And I made that point to Professor Teachout when he was here before, because I don't understand the layers of the separation of powers, and I don't have a judicial background, but I think I just heard the first example that I'm trying to understand, which is the concern that you have with mandatory consultation is that information that is normally not public would essentially become public or become more available to a wider group of people. Is that kind of what you're saying? Because you're saying that if a judge or a lawyer has a proceeding that they have to consult with or could consult with the ethics board on, that ethics board has a different standard of requirement for keeping that information private? Is that? Never mind. I don't know. No, but I'm happy. Let me try to unpack it a little bit, because I can understand why it's difficult to understand or difficult to follow when you're not dealing with it all the time. And I really appreciate that this committee is being thoughtful about all of this material, because it is complicated. It's technical. So what I'm saying is that the Judicial Conduct Board is created by rules and governed by rules that are established by the court. And we have to follow the rules established by the court. And one of the rules we have to follow is that we are not allowed to discuss matters that come before our board with anyone else. Yeah. That is what our rules say. So I, myself, and any other member of the board would be prohibited by those rules, in most instances, if not all instances, from having a conversation with an outside entity, such as the Ethics Commission or any member thereof, because our rules say we can't do that. So, okay, I thank you. That is a very different thing than what I thought you were describing. You're saying you don't want to break your rules. Correct. I'm saying, and I think that makes a lot of sense. Fair enough. But it's not that the information in an ethics decision is private or not private. Like, I guess so I understand you don't want to break your rules, fair, but in the interest of transparency, would this not be a greater step towards transparency for the average person wondering about ethics of participants of any branch of government?
Well, so I'm
Like,
operating.
is there a different, so I guess I'm not trying to make an argument necessarily. I'm trying to understand, is there a different level of transparency then? Or the information is available to more people for if we move forward with the bill is kind of what I think I'm.
And then maybe a tag onto that is, or when is it made?
Yeah, when is
clear?
it? Yeah,
Because I
exactly.
think,
That would
the
reassure me.
I think that the Board of Judicial Conduct, I think you do make decisions public after they've been weighed and made,
Correct.
right?
Okay.
So let me I'm going to take a little bit of a step backwards because when when I was just talking, I was operating from the premise of Professor Teachout's analysis, which only was talking about the period after a complaint becomes public. Prior to that, yeah, the confidentiality rules prohibit any dissemination of the information, period.
Right, so that's like a personnel matter. That is
Right.
considered by the board, but there's no other light on it. But then once the board has made a decision and it is public, that is when is separate.
Talking about once the board initiates a proceeding, which is before the board makes its final decision. So once the board, once a proceeding is initiated, a complaint becomes public, meaning the public now has access to know the name of the judge who is the subject of the complaint and what the complaint is. That is something that any member of the public already has access to. So this doesn't change anything about that. You can go on our website and read every public complaint that has been published. And I would also point out that our board publishes the outcome of all of our cases, including the confidential cases. It just, when they're confidential and there is no public complaint filed, they're just anonymized. So every member of the public can go on our website and find out about every single complaint that is filed that the board has considered and what the result is and why. So there is no greater transparency other than just finding out the name of the judge, which if the complaint isn't substantiated, then why should the judge's name be, because I have to tell you, there are a lot of complaints that are just people who are dissatisfied with the outcome of the court case. And those are matters that I think if we were to publish the name of the judge, I think it would just become very convoluted because people don't always understand the distinction between making an accusation and having that accusation actually substantiated.
Yeah.
Right. So I want to be really clear. All of this is already on our website. It's just that we don't, unless and until it is made until charges are filed, quote unquote, a complaint is actually filed against the judge, they're just anonymized. So there's no lack of information about the basis for any of our decisions. And I've been,
I'm certainly not trying to say that. That's not what I'm trying to say. I truly don't know how any of this works. I'm trying to understand a motive behind why you might want something. And it sounds like that's not the motive. You're not looking for some kind of keeping of information private because you already share all of the information that is relevant for, I think, the layperson to understand where a judge is at to an ethical standard. So yes, I'm not trying to make an argument, but I'm trying to understand. So I appreciate you explaining that to me, and I apologize for interrupting.
These are great questions, but it's also helpful. It's also helpful for me to get the questions because it allows me to figure out where I'm assuming knowledge or information that you may not, that I may have or take for granted that you haven't absorbed yet. So that's really helpful.
Actually, to that point, Meryl, if I may, perhaps you would just quickly walk us through the process. So a complaint comes in, let's say, a complaint comes in about a judge or a lawyer, or let's say judge, because we're dealing with that, comes into the Ethics Commission. The Ethics Commission then files it to you, the appropriate board, who will deal with the complaint and take it from there. Then what happens?
Wait, no, can we stop there even? When you say the ethics board,
The Ethics Commission
the ethics commission.
intakes many,
No,
many complaints.
I don't,
Yes, they
but
do.
no, but they don't, but they could be, they could even not go through the ethics commission. If I had a complaint, I would go to the judicial. I wouldn't go through our state
Yeah, but you
ethics commission.
know what you're doing. A lot of people just don't know where to go and just have an ethics complaint and they send it to the commission. And the commission then sends it to the appropriate body, the Senate, House, the judicial.
Okay, then how would
judicial.
that not break their rules just by receiving a complaint through?
Correct, they receive complaints, just like we do.
I'm still.
No, so we do receive complaints. Most of our complaints are received directly because there again are instructions on our website for how to file a complaint. But I would rein it in a little bit because this provision we're talking about only applies when the complaint has been referred by the Ethics Commission. So that's why we're in that cabin. So when we receive a complaint, you know, it gets docketed on our docket. It is confidential. We review the complaint itself. We can do some limited investigation just to kind of flesh out the details of the complaint in terms of what the complainant really is referring to. A lot of times we will, very, very often the complaints will concern something that occurred during a hearing. So we will listen to the hearing and we will try to figure out if there is any merit to the complaint. Many times complaints will allege things that simply are not violations of the code. No matter, even if they were true, they're just not violations of the code because the judge deciding not in your favor without something more is not a violation of the Code of Judicial Conduct. So there has to be some basis in the actual code. And a lot of times if we feel we don't have enough information from the complainant, we will we will actually sua sponte request that they supplement the information. And we will say, what you have sent to us doesn't identify a violation of the code. Please provide us with more information so that we may consider it within X amount of time. If they give us the supplemental information, we will add that to our discussion and our analysis. The board has an initial discussion about where to go from here. So if we say, okay, even if all of this is true, it's not a violation of the code, the complaint may be dismissed right there.
Oh, wow.
But if it is, well, and just keep in mind that there is a high volume of matters that are simply not something that we can decide or we cannot find a violation for because we are not an appeals court. So we're not there refereeing whether the judge was right or wrong. That mechanism is an appeal to the Supreme Court. That's not what we do. We are purely looking at whether there's been a violation of the code by the judge's conduct. And then if we think that there is a basis to not to conclude that there has been a violation, but that there may even be a violation, then we turn it over to our special counsel and they commence an investigation. They decide whether charges a complaint should be filed. And if so, that's when they file the complaint. And then that goes through the comprehensive quasi-judicial process I was just describing that is just like any other sort of adjudication before an administrative body with all of the bells and whistles. So I would also just to continue a little bit on what my concerns are specific to the JCB rules, the rules for the disciplinary control of judges actually say when the board may provide information about pending matters that have proceeded past that initial inquiry stage. And the only time we may do so, according to our rules, is in a proceeding for impeachment, retention, or judicial appointment. So since this consultation requirement involves none of those circumstances, providing information regarding a pending matter, in my view, would again violate the rules promulgated by the Vermont Supreme Court, which specify when we can disseminate or provide any information. So either we can't provide information as part of this consultation requirement at all, which seems to detract from its functionality for any purpose, or we would be presented with the possibility of violating the Vermont Supreme Court rules were we to do so. I also think that it would be improper. Oh, I'm sorry. Do you have another question?
Go ahead, sir.
Yes. Why couldn't you just change your rules to say, instead of violating Vermont this, we will also just allow the state ethics commission to review?
Well, that is
And
something.
why, how do you change your rules? Like why?
Supreme Court.
the
Oh,
Vermont-
it's the court decides these.
it's the court. Yes, the Vermont Supreme Court's rules.
So how do you change those rules?
Well, those rules, people can present proposed rule changes and the court can consider them, but just keeping in mind that the Vermont Supreme Court has the exclusive authority for disciplinary control of judges. And so the rules that they implement in relation to that subject matter are well considered. And it's not to say that they don't change, because sometimes they do, but those are the rules that we're operating with. I also think it's improper for the JCB, which is intended to be an unbiased fact finder, to allow an outside agency to attempt to potentially influence its consideration of a case before it. In any other context, that would be considered improper ex parte communication, and it would likely violate the due process rights. It could violate the due process rights of the respondent judge. When you have an unbiased fact finder, you shouldn't have them listening to influences that are outside of the context of the hearing on the matter before them. That's something that is prohibited in the normal adjudication of claims, particularly in front of courts. So it just kind of leads me, these rules, these issues, and our concerns about them lead me to the ultimate question, which is, what is the purpose of the consultation requirement? If it's for the Ethics Commission to provide advice to the JCB, that's not something we can do anything with, because we apply the Code of Judicial Conduct. We would not be applying the state code of ethics when we render a decision regarding the discipline of a judge. To me, again, it seems only to serve the purpose of attempting to influence that decision making ex parte, and in a process in which the judge is entitled to due process. So even if the code of ethics had, even if there was some relevant information for me to learn, it would not. I can't, as our board can't apply that code. We have to apply the Code of Judicial Conduct to our proceedings. If the purpose of the requirement is for the Ethics Commission to learn about the application of the code, as I explained, that would violate one or more rules of the Supreme Court that we've just discussed. But also, the Commission could simply read our final decision or any of the other closure reports that are published on our website, which do discuss the application of the code in a properly anonymized format. Which would also avoid the possibility of improper influence of our decision-making process. So, in short, because members of the Judicial Conduct Board will not be able to give or really receive information about matters before the JCB, even after a public complaint has been initiated, without violating our rules, the JCB should be exempt from the consultation requirement. The JCB will continue to apply its robust process for determining complaints made against judges, as it has done for many years, and we will continue to publish the results of those deliberations in the proper format, whether anonymized or public, depending on the circumstances, on our website.
Senator White.
Thank you, Chair Homer. Thank you so much for that. That's really helpful. I still was thinking about all of this in the context of the separation of powers thing. And I don't necessarily agree, if I'm understanding correctly, and again, I'm not a law student, I don't necessarily think it's a separation of powers issues as described, but that's not a determining factor on my position on if you shouldn't have to have consultation or not. that's for lawyers to decide, I guess. But I do think you make a very, very clear case that you already have a well-documented, robust ethics process that I really don't feel like we should mess with too much. So that's kind of where I sit with this. So I appreciate you presenting that. And whether or not this is deemed a separation of powers issue, I could go either way. I just do think that I would not, we do need to change that. Did your final conclusion get you to the place of agreeing with the change that Professor Teachout had recommended to us in his testimony, or did you have alternative language? Or maybe ending that.
You have to separate government kind of people like us with the judiciary, I think. The judiciary is in a much different and special situation. I think all of us, if you knew a judge before he or she was a judge, their life changes 180 degrees when they're appointed. There is absolutely no question about that. Even to the point where if you see them in the grocery store and you used to be able to walk up and just engage in absolutely normal conversation, they're under such immense pressure for this impropriety function that they have to stay away from. They can't even do that.
Wow.
They can't put lawn signs up for political candidates. They can't deviate from the code an inch.
Yes, but I seem to still have good conversations.
I didn't mean to imply that you
In all
can't
sorts of
say.
good ones.
I have a very close friend who's in the judiciary, and we go to a football game, college football game, and he could cheer for the right team. I'm not saying that. I'm just saying very, very few of us, including law enforcement and including us, where we consider ourselves to be on duty 24 hours a day almost.
Such a code.
This is even beyond that for me.
I mean,
So
just based off of
I
the
think
role.
they exercise. The only question I had, and maybe it's more for Carolyn, it seems like the JCB has more to do with judges and the Professional Responsibility Board has more to do with attorneys, but I could be off there.
That's exactly right.
Oh,
Yeah, that's,
Yes,
would it be helpful if Carolyn
Yeah,
shed some light on the other half of this?
Right.
sure. I would
Thank
be
you.
happy. Thank you. Thank you. I'm Carolyn Anderson. I know Senator Callamore. How are you? And I am the chair of the Professional Responsibility Board. Just by way of background, I've been on the board since 2015. In 2018, I was appointed by the Supreme Court as the vice chair. And in 2022, I was appointed as the chair of the Professional Responsibility Board. So the Professional Responsibility Board exists through Administrative Order Number 9, which is an order of the Vermont Supreme Court. It created the Professional Responsibility Board and the Professional Responsibility Program. The board actually oversees the program and ensures that it's operating properly. The program is comprised of Bar Council, Disciplinary Council, and Screening Council. And the Vermont Supreme Court, through the board and the the Professional Responsibility Program, governs all aspects of an attorney's conduct through the rules of professional conduct. And as Merrill noted, the rules of judicial conduct govern judges' conduct on and off the bench. And the rules of professional conduct also govern attorneys' conduct, and they can be retired attorneys, in some instances, attorneys who have applied to take the bar, and they can be attorneys who are not acting as attorneys. So a lawyer who's actually on the board of a nonprofit, or a lawyer who's on the board of a bank, or something along those lines. Many of the rules of professional conduct govern an attorney's conduct, even when he or she is operating in a non-professional capacity. So the Professional Responsibility Program, or the board, will receive a complaint. In this situation, we're talking about complaints that go to the Ethics Commission about an attorney and then are forwarded to the Professional Responsibility Program. Our first step on that complaint is it goes to someone who is known as screening counsel. Screening counsel reviews the complaint and has three options. The complaint, if it's completely lacking merit, can be dismissed right at that stage. And screening counsel does do a limited investigation there. But, some cases are very obvious. I'm complaining about my lawyer because my lawyer didn't file a motion for summary judgment when I asked him or her to do so. And screening counsel goes and looks at the file and a motion for summary judgment was filed and ruled upon. So, that wasn't actually a valid complaint. So something like that might be dismissed out of hand. Another avenue, however, is if the screening counsel feels that there's more information needs to be looked into, either on the law or on the facts, to determine whether there has been a violation of the professional conduct rules. That complaint will be referred to what's the person known as disciplinary counsel. And I talk about disciplinary counsel in the memo that we sent to you. That attorney has a great deal of responsibility, has subpoena powers, can take depositions, etc. So that attorney will begin an investigation. He can hire a private investigator if his caseload is such that he needs more help or more in-depth investigation. And all of that information by rule through Administrative Order number 9 from the Supreme Court is confidential. No information about that complaint or the attorney that it is against can be shared at all. And that confidentiality requirement remains unless and until a public complaint against an attorney is filed. And the way that happens is disciplinary counsel has to go to one of our 10 hearing panels. We have 10 hearing panels throughout the state. Each hearing panel is comprised of 2 attorneys and 1 layperson. And those people are appointed by the board, by me, technically. And they hear disciplinary cases. So if disciplinary counsel feels that a complaint against a lawyer actually merits, it potentially violates a rule of professional conduct, he has to go and seek a probable cause ruling from one of our hearing panels. He presents some evidence, he presents affidavits. If there is a determination that probable cause is found, then the attorney disciplinary counsel has to file a professional conduct complaint against the attorney. At that point, once that complaint is filed, it is public. And usually those complaints are very robust and very detailed. They lay out the facts, they lay out the rules of professional conduct that have purportedly been violated, and they are a public document. You can go to the Professional Responsibility Board's website, and all of the pending public disciplinary cases are there. The attorneys who have been complained against, once a complaint has been filed, their names are there, everything is there, the complaint is there. At that point, we assign that complaint to a different hearing panel, not the same hearing panel that made the probable cause determination, but a different hearing panel. And it's like a trial. There is discovery, there can be depositions, there can be, motion practice. The Vermont Rules of Evidence and the Vermont Rules of Civil Procedure apply. And frequently the attorney is represented, the respondent attorney, the one against whom the complaint has been made, may appear on his own to represent him or herself or with counsel. And there is a hearing. The hearing panel also has counsel that helps with the motions and the drafting and things along those lines. And there's a whole hearing. Those hearings are public. They're recorded, and all of the motions and things like that are filed on our website. After the hearing panel has to issue a decision. obviously either finding that there was a violation or there wasn't a violation of the professional conduct rules. That decision has to have findings of fact and conclusions of law. And if there is a finding that a rule or more than one rule has been violated, then there also has to be a section of the decision that lays out the sanctions. The sanctions that can be imposed, I went through those in our memorandum as well. They can be anything from an admonition, a private or public admonition, suspension, disbarment. And obviously that depends upon the gravity of the infraction and other things such as whether the attorney has ever had a professional conduct complaint, other findings against him or her. So after the hearing panel issues the decision, either the attorney respondent or disciplinary counsel can appeal that decision to the Supreme Court. And even if neither party appeals the decision to the Supreme Court can take that matter up on its own and issue its own decision. And I think that just is a good reflection of how important this is to the Supreme Court, how seriously it considers its obligation to have the disciplinary authority over the members of the bar in the state of Vermont. And the Supreme Court has frequently, particularly this court, in the past several years, has frequently taken those cases up without an appeal to sort of get its, put its stamp of approval or change, particularly the sanction. And sometimes we'll see the Supreme Court actually increase the sanction imposed on an attorney. So that is the process. And like Meryl stated, I think that Professor Teachout was helpful in explaining that the original language of H1, which would require us to provide information within 60 days of the filing of the complaint, is just impossible for the PRB or the JCB because those are by law confidential and we can't disclose that information. So he concluded that perhaps we could give the information after, we could have a consultation after the complaint has been made public. And on that, I guess my question is, for what purpose? Once the complaint is public, there is a public complaint, which would tell the Ethics Commission precisely what we are doing with that complaint. We filed a charge and it will lay out very detailed exactly what facts we're relying on and what rules of professional conduct have been violated or purportedly violated at that point. And then all of those proceedings are public. So I can't fathom really what the point of a consultation would be at that once the complaint has been filed. It's all public information. The only other thing, as we sort of noodled this around on what would we provide, would be, I guess, the only thing left would be disciplinary counsel's impressions of the case, his trial strategy, his feelings or opinions on whether he has a strong likelihood of success on the merits or doesn't have a strong likelihood of success on the merits. And all of that information is very strongly protected by both common law and rule and case law in Vermont, and even the US Supreme Court. It's called work product, attorney work product privilege. And that information, the attorney's impressions of his own case, his trial strategy, his opinion on whether he might win or lose, that's all protected information and would not be shared ever, honestly. It's even protected from our public records requests. I think there's a Supreme Court case right on point where that kind of attorney work product information was deemed is not allowed in a public record request. So I guess when it's all said and done, Before a public complaint is filed, the information is absolutely confidential under Supreme Court rules. And after a complaint is filed, the information is public, and the only information really that would be available would be work product privileged information. So that's the attorney world on this side.
Senator Clarkson.
Thank you both. Very helpful. I just am curious, how many, with both of you, with Carolyn and Meryl, how many complaints do you get each year? And how many determinations are issued, or how many are dismissed?
So hold on one second, because we actually publish an annual report every year that has all of that information, and I happen to have one handy for the most recent year. And these are published on our website as well. But let's see, for the last year that we had, for the last fiscal year that concluded in 2024, we received 36 new complaints, and we had 3 complaints still pending from the prior year. So that's a total of 39 that were dealt with in the last fiscal year that the board decided. We have a new fiscal year. We don't have an annual report completed yet for this fiscal year because it has yet to conclude, but that is the most recent year. Let's see, 35 were dismissed after initial inquiry.
35 of the 39 were dismissed.
Mm-hmm.
Yep, and but some of them were but let me just also indicate that doesn't always mean an outright dismissal. Sometimes that can actually mean that the judge entered into a deferred disciplinary agreement or something along those lines. So it doesn't mean that there wasn't something that actually happened in each of those cases.
Got it. So sometimes there's sort of a mediated corrective action.
Right. But a lot of them were found to be outside of the board's jurisdiction or to not allege a complaint, a violation of the code. Let's see. There was one instance where, I don't want to just give you all of the, recite all of the findings in the report, but.
No, but of the others, so 35 were dismissed. Some may have had some mediation work done and improved requirements attached to them. But does that mean there were 4 that were actively determined that there was a challenge or a problem? And
one of them resulted in a written warning. And then 3 of them are still pending. So which means they're in the investigation phase, which means that there is some reason to believe that there may have been a violation, and it's being investigated and will either be, following that conclusion of that investigation, it may be that there's a determination that there's no violation or no probable cause to believe that there was a violation, or they may proceed to a public complaint. And if you look at our website as well, there have been several matters that have resulted in severe disciplinary sanctions against judges in the last several years, including 2 judges who were essentially barred from ever serving in that capacity ever again in the state of Vermont.
Carolyn, do you have similar figures for the attorneys?
Yes, I do. So I wanted to go through a little bit because our program has both a complaint aspect, but we also have what's called ethics inquiries, which we believe actually keeps our complaint numbers down. So our bar council receives inquiries from practicing attorneys about ethical issues, ethical concerns that they may or may not have. And he gets those in the hundreds, which he will then talk through issues with attorneys, and he doesn't tell them what to do, but sort of goes over what the rules are and things like along those lines. I'm looking at our annual report for fiscal year 24. It has not yet been published, but it is final. It hasn't been sent to the Supreme Court yet. And so Screening Council in 2020, in fiscal year 24, Disciplinary Council had 21 cases referred from Screening Council. And Screening Council had a total of 175 complaints sent in to him.
175.
175 complaints, and of those, the Disciplinary Council, there's the timing doesn't precisely line up on the fiscal year, but the Disciplinary Council had 21 cases.
Got it. Thank you. Well, that gives us a notion of the number that are being dealt with every year.
Mm-hmm.
And then, of course, with the judicial, we also have the judicial retention work that's done here at the State House, which complements this work as well.
That's right. It does. It does. And there is information sharing in that process.
Yes, there is.
So as vice chair of that committee, I'll just ask Meryl if I could, what the threshold is without being specific and certainly identifying anyone. I assume being grouchy is not a breach of, I mean, those are the kinds of things where we do, because they have surveys. I still have my little book here.
Your big book.
Big book. And oftentimes, in my view, attorneys are a little more severe in the way they view the judicial system than staff is. Staff generally gives them pretty much higher marks than the attorneys. But more often than not, most of what we hear in terms of negative reaction has to do with behavior and
interpersonal.
Yeah, temperament and that sort of quality, I guess, or lack thereof. But I'm wondering, that doesn't rise to the level of a breach of the code of conduct, correct?
It actually can, and in many instances it does. It depends on the circumstances. And, you know, I certainly can't give an advisory opinion after saying how I can't give advisory opinions, but there are certain rules that may come into play that would cover that type of complaint.
Okay. Well, again, committee, for benefit of those of you that haven't sat either on judicial nominating or retention, the judges are held to a pretty strict conduct code. So and again, I appreciate Professor Teachout, both his initial testimony, which we heard last Friday, and then over the weekend sent us an additional one, which has more to do with judicial than the two Senate and House panels here. But his conclusion with respect to the judicial world, I think, is correct, that you have a much more robust process, and that if it's just a post-decision or post-complaint situation that he's asking for, he can glean most of that information already by going to public sources where everybody can see it. So I'm not sure what is gained in the end from that. So I know we're going to have to take more testimony. I'm not suggesting that the committee vote on this today. We have Betsy Ann Rask and John Bloomer coming in next week to offer their views on H1 and what the committee should do. Obviously, in the House, it's already been decided. That's why we have possession of the bill. They decided to exempt both the two panels within this building and the judiciary. So I don't know if there are any additional questions or comments for people here. You make a pretty powerful case, in my view, and I think Senator White indicated thus as well. So thank you for your speech today, and wish you well. And Carol, it's always good to see you.
Well,
You too. Thank you.
we very much appreciate your time and consideration and interest. And if there's any other details or data, we're more than happy to return.
Okay.
But thank you for listening.
Sure. And thank you for the cookies.
Thank you very much.
Thank you. Okay, committee, why don't we take a 10-minute, 15 minutes? What do you want to do? 10 or 15?
Everything.
I mean, my
Oh,
preference
thank you.
is 15
15-minute break because it's better for you.
Loves their
Fifteen,
Friday.
And
that's
we will hear
long.
from